All right, very good. Thanks so much. And thanks everyone for spending 30 minutes with us. It's the ERTC, the Employee Retention Tax Credit, the $26,000 has blown up into a very big deal. You probably are seeing or hearing on radio, Sirius XM, or even on TV now. There's several different companies that are doing this, and hopefully in 30 minutes I can give you at least a good overview. And largely it really kind of depends on the details of your business, and we're here to be able to give you a little bit of that information, but more importantly, at no cost, review whether you qualify or not. And we are, myHRCounsel is a law firm. So we are lawyers. We're held to a legal standard. So, if you're worried about some of the things that you see on TV or some of the things you read that are popping up on your computer, and maybe those companies are not necessarily backed by, the legal rules and malpractice insurance, et cetera, know that at least, you have that protection from us. And at this point, we've done over, I think, 500 clients' tax returns, the amended tax returns for the tax credit. So we have learned along the way as the IRS has come up with more rules and more clarification as we go on. So I'm going to apologize on the front end. If it bothers you not to see the full screen presentation, I have 3 screens going, and for whatever reason, I couldn't get it to do the full screen. So we're just going to do it in the presenter view, and you can follow along to see if I'm almost, done. If you're getting to the point of I can't stand Mark talking anymore, you can see what the last slide is. So maybe there's an advantage there. Let me start with the ERTC and really what it is. It really is a combination of the COVID legislation that came out of the CARES Act, and I think really got more clarification around the American Rescue Plan, and specifically one of the 2 qualifications that companies are able to use. It does provide tax credits for and paid tax credits, not credits that you can use down the road. They actually send you checks for up to $26,000 per employee, and they're considered refundable credits. That's again goes back to the paid tax credits based on the employee wages that you paid. The benefit is the $26,000 per employee and the wages that you paid that employee. It's broken up into a couple of sections. One is in 2020, from the period of March 15th to December 31st of 2020, you can get a refundable credit of up to $5,000 per employee. And there's a little bit more calculation that goes on because, you're taking three quarters and you're getting up to $5,000. So if you're paying your employees more, maybe $50,000 to $100,000, you may use up that whole $5,000 in that second quarter of 2020, the March 15th-ish to June 30th. If you pay your employees about $40,000, then each of those 3 quarters will add up to a total of $5,000. Where the larger dollars come from is really the $7,000 per employee, and that's for 2021, quarters 1, 2, and 3 of 2021, which means, of the $26,000, $21,000 of it is available in 2021. So we have seen some clients that maybe in 2020 we were, in the midst of shutdowns, et cetera, and maybe by the 3rd quarter or into the 4th quarter, they had talked to their accountants. They said maybe you didn't qualify, and then they didn't look at it again. And we've had many clients that have come back after, really as we got into the 1st and 2nd quarters, or towards the end of 2022, actually, where there's been more clarification from the IRS, and had a chance to look again at clients' information and their payroll information, and found out that they do qualify for that $21,000 again, that adds up pretty quickly when you think about, if you have 10 employees at $21,000, you're talking about $210,000 of paid tax credits. So definitely worth looking at. And again, we're happy to do that at no charge, no obligation, just to see if you do qualify. And if you do qualify, what risk you'd be taking by filing. From an eligibility standpoint, there's really two rules. One is, I'm going to go backwards. One is what I think a lot of people heard in 2020, and that is if you had significant drops in your business receipts. And significant is when you took a quarter in 2020 and you compared that with that same quarter in 2019. If that quarter dropped 50% in business receipts, you qualify for the employee retention tax credit. Then in 2021, they changed that so that if your business receipts dropped 20% when comparing the same quarter in 2019, then you qualify for the employee retention tax credit. So a lot of people looked at that and said, well, my business didn't drop 50%. There's a lot of us accountants who said, that's pretty easy to figure out. We'll just look at their business receipts. We'll compare it to a quarter in 2019 and find, no, they, while they were closed for the second quarter, maybe they were half open in the third quarter of 2020, they only dropped 30%, so they don't qualify. And for some reason, what got overlooked is the second bullet. Richie, is my first bullet, but the second qualification rule, which was if your business operations were fully or partially suspended due to COVID-19. And when that first came out, I think a lot of people said, well, listen, I was closed for 4 weeks, or I was, we had to shut down the office, but we were able to work from home. And yeah, well, we didn't have the same, clients couldn't come in and visit us. We did, we used Teams, etc. People kind of passed that and said, yeah, and we probably don't qualify for it. What changed is, about a year after these all came out, the IRS started to, again, Congress passes these bills and then moves it up to the IRS to, to work the process, to work the tax returns. And when the IRS gets it from Congress, they have to then use their rules and put out revenue proclamations, et cetera, and clarify for taxpayers what it is we as taxpayers, we as professionals need to file, and what is going to qualify as a partially suspended business. The IRS has now put out, I think, over 100 FAQs and examples of businesses that they have decided, would qualify as partially suspended. And I use the example of a restaurant. So if a restaurant in the second quarter of 2020, when, everything, hit the fan and closed things down, restaurants, let's say they were closed for 8 weeks. After being closed, the government said, well, but you can, have takeout, or as long as you're wearing a mask, you can go through the drive-through. And the IRS has said that's still partially suspended your business because you were not open in-house. You didn't have your on-site restaurant open. So you qualify for being partially suspended through that period of time. The IRS goes on further with restaurants to say, okay, and then once you opened on-site and you had 6 feet distancing, or you had, I know in Minneapolis, we had a 50% capacity limitation rule that went all the way into 2022. So for all of those quarters, again, the second, third, and fourth quarter of 2020, and the first, second, and third quarter of 2021, if you're a restaurant or similar businesses that had restrictions on how many clients could be in your office or on site, you were partially suspended, and you qualify for the $26,000, or the ERTC as we call it. So this is a really important one. It is, I'll be real honest with you, it's still enough of a gray area in that, we're not a year or two down the road where the IRS has maybe come back and audited some of the companies where just to see if they truly were suspended, or if they truly were held to capacity rules. Minneapolis was different than, Dallas in terms of what some of those restrictions were. So it isn't just a freebie to say, well, of course, I was partially suspended because, I had one little thing happen. The IRS has, again, in these 100 FAQs, given more detail. And again, our professionals have reviewed this. We've spent the last 9 months really looking at the details of the bills as well as these FAQs. So take advantage of our partnership with Greenshades and make sure that you use us to take a look at it. Again, I won't spend too much time on the significant decrease. We know how to calculate that. If it's dropped 50% from a quarter in 2020 versus 2019, you qualify. So not a lot there. It's really taking a look at, and there are some, what qualifies as business receipts, and what if we expanded businesses, or what if we bought a business during that time. So we'll look at that certainly. But if you think that you might qualify for this, or in 2021, you might have dropped 20%, again, comparing to a quarter in 2019, we'll take a look at that. Most of you, if you're on here and that happened to your business, if you survived with PPP loans, and you probably had a lot of help from various different professionals, and you probably have looked at to see whether you qualify for this. What is really, again, I think more the the gray area, but the professional area to look at is really this full and partial suspension of business operations. So a couple little ground rules. Again, it's an alternate to the method, but it's not an and. In other words, you don't have to have dropped 50% and 20% and have a partially suspended business. This is an or. So if you don't qualify for the, again, the drop in business receipts, this is, or if this happened to you. So this works on its own. It doesn't have anything tied to it that says you have to have dropped by a certain amount. You do have to show there's a direct correlation requirement in showing that the government, or whether it's federal, state, local, school board, whether it's Dr. Fauci, who was giving us updates on masking and social distancing, all those new words that we learned, there has to be a correlation. But all of those things together, or if it's significant enough within its own, go to making the argument and qualifying for a partially suspended business. In order to figure out if you're an eligible employer, it is focused on smaller to medium-sized businesses. So it is companies with less than 500 FTEs. It's available for the amount of qualified wages, and there's some definition that goes into that. One of the rumors that we hear, and a lot of people, I think, when they first saw this said, well, I got a $200,000 PPP loan. It was forgiven by my bank. The federal and state government said that that wasn't taxable, so I can't qualify for the employee retention tax credit. Well, that's a wrong rumor. You actually do, but you deduct the amount of the PPP loan that you used for payroll against what is your qualified wages. Now, what we have found, although I did find one client out of the 500, and they must have been great negotiators with their bank, but typically a bank did not give any of us businesses, more than about 40 or 50% of payroll in a PPP loan. And if that makes sense, just from a general, business standpoint, in that a bank typically, if you're struggling and you can't make payroll, the bank is typically not going to lend you 100% of your payroll. They're going to say you have too many employees, you may want to lay them off during a period of time, or you may want to close your business until the receipts come back. Because again, the bank still was lending based on your ability to repay, even though they knew, or at least we had a pretty good idea, that the federal government was going to back that loan. So typically, if you had a PPP loan, or you had two, if you had one in 2020 and one in 2021, it will reduce the amount of qualified wages, and therefore the amount of your employee retention tax credit but we have yet to see a PPP loan or a company with 2 PPP loans that doesn't at least have some leftover qualified wages that do qualify you for the employee retention tax credit. In terms of claiming your credit, again, for sure, contact us. Your first step is info@myHRCounsel.com, or to reach out to your account managers at Greenshades. All that we need to look at is your second, third, and fourth quarters of 2020, your payroll reports. And really, if you think about that, these are your quarterly gross payroll reports. So you have that. That's a very typical payroll report that comes out, because you have to file your quarterly tax and withholding, both for federal, your 941, and for your state. It typically has your quarterly withholding that you have to report. So you can run your payroll report, or you can typically look at your 941 or your state quarterly returns. And as long as that breaks out your quarterly payroll roll wages by individual employee, that's all we need to do. And again, it's 6 quarters, so first, second, and third quarter of 2021 also. We do file all the forms if you qualify. All you have to do, again, other than sending us payroll reports, is to sign the page where you as a taxpayer, and unfortunately it's and we'll mail those for you then. What the IRS does then is, once they get them, and they're we hear they're piled up, millions of returns in Cincinnati and Ogden, Utah. It's taking about 4 to 6 months to turn that around. However, 4 to 6 months is starting to get a little bit better as they're processing, and I think they have their scanning machines working, et cetera. So now we're seeing maybe closer to 3 to 4 months, but still worth it when you think about $26,000 per employee. And then upon receiving your credit, we do have a fee only after you've been paid of 15%, and I'm going to talk a little bit about, we're going to reduce that for Greenshades clients. The act fast, my last bullet, is we're getting to the point where for your 2020, that $5,000 tax credit, we're starting to run out of time, and that when we get to April of 2023 here, just a couple months away, the 2020, the $5,000 employee retention tax credit will have run out. 2021 doesn't run out until April of 2024. So you have some time there, but again, the sooner you get it, the sooner you get in line with the IRS, and you don't miss out on the first 2020 employee retention tax credit. So I'm going to, rather than talk a little bit more about myHRCounsel, there's a couple of things that we have learned along the way, and a couple of things that I would have people walk away and really stress this issue. Ask a professional in terms of this. I've heard some crazy rumors that the IRS has already put people in jail. That just can't possibly have happened. If you think about, in the last 2 years, many of the courts have been closed. So if somebody filed in good faith, filed their employee retention tax credit, they probably just now are getting the tax credit paid through the mail. The idea that the IRS has somehow turned that around, filed a lawsuit, gone through an appeal, and arrested a taxpayer who, again, filed in good faith, is just not true. And you start thinking about some of these rumors that you see, and there's a lot of stuff online, a lot of social media, a lot of, again, people who have either decided just to scare people, or people that have decided, I missed out on helping out these clients, and so I'm mad, and I'm going to just say, well, there's a lot of risk there. The fact is, for myself, I've been working with the IRS for 33 years. If you are a good faith taxpayer, you're not defrauding the federal government, the state government, which is against the law, whether it was the employee retention tax credit or any other filing. If you file your 1040 and you defraud the government, you're going to be in trouble. So when we're looking at this employee retention tax credit, we're filing under, again, reviewing the IRS rules and their FAQs and examples, and we're applying your facts and circumstances on a good faith basis. We're not, again, making up things. Oh, something happened to my business. That didn't happen. You know, when we look again at that example with the restaurant, think, you know, we can all think about, because we went to restaurants, but if you own a restaurant, you can all think about those steps. All of those steps did partially suspend your business. It did not grow at the rate that it would have had it not been for the pandemic. If you were flat during that period of time, or maybe you were a genius and you figured out ways to, you know, even do well. The fact of the matter is, the way that this law reads, from Congress to the processing to the IRS and those clarification rules, when we have really looked at this, and we're a pretty conservative bunch as lawyers and tax accountants, but as we have looked at this, when you put these things together and you list out 5, 6, 7 different things that the federal government, your state government, your school board, you know, think about how many times schools and daycares were closed and your employees called in that day and said, you know what, somebody, you know, one of the kids got COVID in our daycare, so we now have to quarantine for 2 weeks. And you as an employer, as a business, all of a sudden didn't have those employees. And therefore you know, if you're a clinic, you couldn't see the same number of, you know, of patients. You think about it again in a clinic. If you went to the doctor, remember we had to sit, we had chairs backwards and we had to sit, you know, side by side. You had to wait in your car. Some people got tired of it and left because they didn't want to sit in their car, and therefore we all had, again, negative effects on our business because of these different things. And again, not the government's fault. We're not blaming the government on it, because they were doing the best they can. Let's you know, again, apply the rules as they are. And again, through good faith, we're looking at the different restrictions that and partial suspensions that were put on our businesses and filing based on that. So I would say with that, again, take advantage of myHRCounsel in our process, in our partnership with Greenshades. There's nothing that gets hurt. We're not going to hound you after you give us the information and we look and see that you qualify. If you decide not to, and we've had clients that have done that, that's totally fine. As I said, maybe I'll hit the last thing. I said there's a couple of things that the bunch of you that are on and gave us 30 minutes today, a couple of special announcements. One is, I know originally I had said 15% is our fee after you've collected and gotten the checks from the IRS. We're going to make that 10% for all Greenshades clients, and it's not just especially because you were on the webinar this afternoon, but we are going to reduce that fee just to 10% as part of our partnerships to Greenshades. And the other thing, and I think you're going to hear more about this from Greenshades and their marketing department, as well as from your account managers, and that is at the first of the year here, we're going to provide a complimentary subscription to what we call Ask HR Lite. And if you go to https://www.myhrcounsel.com/Greenshades, you'll see what I'm talking about. But what it is it is our employment law advice at no fee, which means if you have again, whether it's a question on the ERTC, but let's say you have a question on you did a background check as part of your hiring process, and you have a question as to, you know, can I hire this person, or if I don't want to hire this person, what is my risk? Those are, because you're a Greenshades client, that will now be included in your Greenshades package. So again, this is, myHRCounsel is staffed only with attorneys in terms of the questions and answers. So you're getting legal advice, which is, you know, not nothing wrong with outsourced HR, et cetera. But if you look at the small prints and you see that, you know, an HR consultant cannot give you legal advice, they're not your lawyer. And so they have to have small print somewhere that says this is for informational purposes only, or it's a starting point, and that you should always review this with your legal counsel before acting on this information, which is great. Starting points are you know, good. It's why we go to Google and we start there. But when you have somebody who comes in and says, I think I've been discriminated upon, and your first phone call or your first email is to an HR consultant who says this can't be legal advice, well, guess what? As you share that information, that's not protected legal advice, and therefore it's not protected under the attorney-client privilege, which is really important. If you have some question, if you're worried about, you know, we want to let someone go, or we hired somebody or we didn't hire somebody that maybe was in a protected class, and you want to have that discussion openly and honestly, if you share it without an attorney and, you know, admits different things, all of those are going to be subpoenaable. Yes, it is a word, when you go to court. Versus if you know, get a hold of myHRCounsel and you're dealing with an attorney, anything that you share with that attorney is protected by the attorney-client privilege. So that's where one of the biggest differences. Not only, again, we don't disclaim any of our advice because it is legal advice, but two, when there's something that comes up and you're going to share that information, and you want to, you know, again, throw out some, you know, maybe just some opinions, or you want to throw out a couple of questions that you might not want to have blown up in a big sign in court, you want to get a hold of your attorney first. And that's what we are. We're on demand. Like I said, it's complimentary as part of your client relationship with Greenshades. So with that, I will I guess I'm right at 30 minutes. And so sorry if I talked quickly, but it's a lot to talk about in 30 minutes. Take 15 minutes and reach out to myHRCounsel and see if you qualify. It's definitely going to be worth it. Thank you, everybody. Have a great day.